As more and more of our correspondence and communications move to electronic formats such as email and electronic transmission of documents, the use of these in litigation becomes more and more prevalent. However, they also pose a number of challenges. Hello, I'm Nerino Petro, Practice Management Advisor for the State Bar of Wisconsin's Practice 411 Law Office Management Assistance Program. And in this series of Practice 411 Fastlane, we're here with Bruce Olson, President of ONLAW Trial Technologies, to talk to him about electronic and computer forensics evidence. Bruce, first, can you give us an overview of what ediscovery is?
Well, e-discovery is nothing more than traditional discovery, except that it's the discovery of electronically stored information, which in this day and age has become much more ubiquitous than the traditional paper-based discovery.
So, is e-discovery a do-it-yourself proposition?
It can be if you know what you're doing, and certainly there are plenty of lawyers who've taken the time to learn the area and understand the technology and the substantive case law that's there. But for many people, they lack the technological knowledge and lack the time it takes to keep up in this very quickly changing area of the law. And so oftentimes they turn to e-discovery consultants, whether they're private consultants or vendor-based consultants, to help people out dealing with the production of electronically stored information.
So we hear a lot of phrases as they're involved with this new area of the law, really. What is computer forensics?
Computer forensics is something a little bit different than e-discovery. Computer forensics is the effort to analyze or first acquire in a verifiable way the contents of a computer hard drive, to analyze it for information. It may be deleted files, it may be to track activity, maybe internet-related information, and then to generate an expert report to validate the opinions that the computer forensic examiner would offer to describe what had been done with that particular computer.
Well, as a follow-up, I think, to those last two questions, when would a lawyer engage the services of a computer forensics expert or even an e-discovery expert, and what's the difference between the two of them?
Well, there is a difference between the two. In general, an e-discovery consultant or expert is someone who will have the general expertise in helping to identify, preserve, and produce electronically stored information, but this is typically information that is maintained on an active basis, active live files that are available to be harvested following appropriate techniques. A computer forensic person, in contrast, is someone who can dig deep down under the hood. They can recover deleted files, they can recover remnants of files that may be left on a computer hard drive, and typically the focus is on one particular hard drive or a server, and is much more particularized in terms of what the computer forensic expert is looking for.
So when would be the best time to engage them if you're going to be doing e-discovery or need a computer forensics expert?
Well, regardless of the type of expert you retain, the key is to get them involved immediately as soon as you know that there may be issues related to computers or electronically stored information in the case. The problem with electronic evidence is it's volatile, and if you don't have someone there to advise you on how to properly preserve the information, you can find yourself guilty of spoliation of evidence, which can lead to downstream sanctions against you. You can lose the ability to recover information. All of this requires someone to get on the scene as quickly as possible.
Well, Bruce, thank you. And that ends our first part of electronic and computer forensics evidence. Tune back in for the next episode of Practice 411 Fastlane for part 2 and part 3. Thank you.